Okay, good afternoon, everyone. Let's see about getting started with this. We're here for the panel on trespass in Indian country, which I'm sure all of you have had run-ins with at least one way, shape, or form. We have three panelists today, one of whom is hopefully going to be going on Zoom. She's meeting with the State Attorney General, so she may skip out, I don't know. And our other two presenters, Rebecca Ross, who's with the Department of Justice, and Kimberly Yearyean, who is with the BIA Regional Office in the Pacific region here. So we're going to get three different perspectives because the third speaker is Merri Lopez-Keifer, who is the California Attorney General liaison, the tribal liaison. So I will let them all do further introductions of themselves. Please keep questions to the end of the presentation, and we need to get everything recorded, so if you'll just go up to the mic in the center here with your questions, then we can do it that way. Thank you. Kim's first one.
Good afternoon. I hope everybody's still awake. It's getting late in the day, and so we'll hopefully get through this. I'm Kim Yearyean. I am the Regional Realty Officer for the Pacific region. My disclaimer is I am not representing the Bureau of Indian Affairs. I am only representing the Pacific region. So I will do my best to answer any questions that you might have, and we'll get through this. This presentation that I'm going through is normally like a 3 to 3.5 hour presentation, so if it seems like I'm running through it, I probably am. So we'll go ahead and get started, and some of what I'm going to talk about may be some basic information that you already are completely aware of, but there may be some who are not. So we're going to just go ahead and run through it. To begin with, a lot of what we end up with in trespass is dealing with fractionation, and as fractionation happens when a probate happens on an allotment. Fractionation is on allotments, and you can compare it to a corporation. If you had a corporation and you own stock in that corporation, you wouldn't be able to identify what part of the corporation that you have an interest in or you own. You own an interest in the whole. So that's the idea on an allotment with fractionation and our undivided interest ownership. So your identification of the interest that you own a share of cannot be identified on the ground with any specific acreage. We have title status reports that we are able to provide to individuals. The title status reports on the first, this is what the first page looks like, that identifies the tract number, the county, the meridian, that kind of thing, the legal description, the section, township, and range. That's what a title status report looks like. I would draw your attention in a title status report to this page, which is Appendix B, that starts with the list of ownership. So every individual who has an interest on the allotment will be listed. There's a column that shows the title, which will identify whether it's a fee interest or a trust interest, and that's the beginning. The first ones that are listed are always the fee owners. And then I have those circles there to try to help identify. The example there is that's one individual, but you can see there's two fractions there. And then, so that last circle on the very right is really what you want to pay attention to. That's where you'll get your percentage. So like if you're going for either a lease or an easement and there's a regulatory requirement for a certain number of consents, that's the number that you would want to use as your percentage for how much consent that you have or haven't gotten. And of course, if you're going for a certain percentage, you always want to go after those highest interest holders first to try to get to the number that you need for whichever transaction you're taking care of. Something that we always try to tell everybody is to keep your address current, have a will, report a death of your family, and do estate planning. We're not going to totally get into that, but that's a whole other discussion. And I just want to run through some of the landowner rights. Each co-owner is entitled to a share in the possession of the entire property, and no one can legally exclude another from a part of it. And this holds true no matter how big or little the ownership interest is. But of course, depending on use, there are lease requirements and that kind of thing. But nobody has the right, we hear a lot in how things happen out on the property where somebody will say, no, my grandma told me that I could use all this land and you can't be here. And so legally, the co-owners cannot do that to another co-owner. If a co-owner is excluded from use or possession of the property, they may seek compensation from the party or parties that are excluding them. And each co-owner has the right to free access on and off the property. Co-owners can request that land is partitioned. Partition is very difficult if you haven't ever been involved in a partition because everybody has to agree. And it's not in a partition, the ownership separation, when it becomes divided, is not based percentage acre to acre. It's based on value. So you have to do a valuation, you have to do a survey, frontage road. If there's a frontage road, that road area has a greater value and that kind of thing. Again, I don't want to go too far down that rabbit hole because that's not what we're here to talk about, but that's something that is available. And it's difficult because sometimes when a property has so many co-owners, it's just not feasible to do a partition. Any co-owners can bring or defend an action against third parties for enforcement or protection of their rights. But if there's a judgment that comes out of that, the settlement would be to the benefit of all the co-owners in proportion to their share in the land. A co-owner can appoint someone else as his or her agent to aid in the prevention of waste, trespass, damage, etc. But whatever action that appointed person takes, the co-owner who has appointed them is the one that becomes responsible for that that action. An owner cannot dictate to the other co-owners the management of any common property, nor can he or she specify a co-owner can live upon the common area. A home site lease or other written agreements are required, and that's where we get into, I'll get a little bit more as we go into the requirements for home site leasing, but for by and large, that's where a lot of our trespass comes from, is residential occupancy without a home site lease. So absent a home site or residential lease, all improvements to that are affixed to the property become part of the real property. And while this is controversial because of some of the stance that the Bureau has taken and has been taken in statute, that even some of those things that become attached to the real property are personal property. But people need to understand that they're taking a chance when they're affixing something permanently to the real property, that it could become the property of everybody who owns an interest in the property. And the owner of a life estate has the right to undisturbed use and occupancy of the property, as do the other co-owners of the property. Again, consent requirements, lease requirements, and that kind of thing come into play. The life estate tenants are entitled to the income that's derived from the property. The remainderman, which is the interest that is encumbered by the life estate, is not entitled to any income that might be generated from the property. The owner of the life estate doesn't have any right to cause waste or destruction of the property, even if they have permission to live there. They can't dictate to other co-owners, they can't cause waste or that kind of thing just because they have the right to use the property for their life. The future interest holder, which is the remainderman, in the property have the right to protect their interest as well. And however, future interest holders, which is the remainderman, do not have the right to current use and occupancy of the land without the consent of that life estate tenant. A son, daughter, grandchild, or other relative of an owner has no legal right to occupy the property unless that right is authorized by a Bureau-approved lease. Like I said before, we get into that issue because there are people who are out there living on the land. Maybe grandma had a house on the allotment, maybe when she owned the allotment 1/1, and she has now said, you can go live in that house, or you can have that house now, or whatever the case might be. If that property is now in an undivided interest state, that grandma's permission's not enough. Sometimes people think that a notarized statement is a valid form of permission to use an allotment, and that is not true. Consent requirements are applied, and any valid lease of any valid use would require bureau approval, secretarial approval delegated to the BIA. When there is a fee interest, we don't, when we're calculating consent requirements and how much consent we have gained for a use, we don't consider the fee interest. We don't use that in the calculation, and any contact with the fee owner is the responsibility of whomever, whether it's somebody that's wanting to lease the property or get a right-of-way, and that we do not track the fee interest. Once it goes into fee, it stays in our system, it stays in the name of who it went out in fee to. We don't track that and keep that information updated. That's supposed to be kept in the county. Sometimes it is, sometimes it isn't. If you own an allotment that has a fee interest in it, we often suggest that you watch county tax sales. Sometimes the counties, if somebody's not paying the interest on that fee interest, the county will put it on a tax sale, and if you can acquire that interest through a tax sale, 2216, which is a provision in APRA, has provided for a mandatory acquisition. If there's still trust interest that exists and you go and get that fee interest, you can bring that back into trust under mandatory acquisition, and I'm not going to go into the requirements and or provisions for that, but something to keep in mind. So for consent requirements, when you do need a lease, if there are 1 to 5 owners, you would need 90% of the interest to consent. If there are 6 to 10 owners, you need 80% consent. For 11 to 19 owners, you need 60%, and for more than 20 owners, you would need 51%. The caveat here is, and I don't think I have this in another slide, but the compensation requirements, if it's co-owner use, oftentimes landowners will waive rental requirements if it's another landowner, a co-owner who's using the property for a residential lease or something. But if it's a lease where there is compensation involved, then you have the ability for those individuals who consent. Let's say you have more than 20 owners, so you need 51% to consent to have the lease. And let's say that 51% waives their right to compensation. Even if it's a co-owner, that other 49% who hasn't consented is entitled to compensation. So if a co-owner is wanting to lease for residential purposes and not have to pay rent at all, they're really going to have to go after 100% to waive compensation. For the requirements of who must obtain a lease, if you're a person or legal entity who is not an owner of the land, then you must obtain a lease that is in compliance with 25 CFR 162. And if you're an Indian owner of a fractional interest, then you also must obtain a lease under the requirements of 25 CFR 162. If you're an Indian landowner who owns 100% of the trust interest, then you do not need a lease. And if you're a parent or a guardian of a minor child who owns 100% of the trust interest, you don't need a lease. So that's where we get into what creates a trespass. And when a lease is not executed and approved, and a co-owner takes possession of the land and builds on the property, that's considered a trespass. Even if it's a co-owner, it's considered a trespass. and the consequences of trespass are subject to the jurisdiction of a tribal court or the United States Department of Justice. And I'm going to let this one over here talk about that. Any complaint of trespass should be filed with the Bureau of Indian Affairs with jurisdiction over the subject lands. We need the name of the trespasser, the address of the trespasser, and any other pertinent information. And sometimes this is also very difficult because you may have somebody who's just a squatter living on the land. You don't know who they are. You don't know where they came from. Maybe they were homeless, transient or something, and they just saw a piece of property that nobody was using and copped a squat. And so you may not know who they are. You may not know how to get a hold of them. You may not know any of that information. It makes it very difficult for us. We do have to follow up a complaint of trespass with an investigation. We have to go out on the site. So we could potentially get that information, but if we knock on a door and they don't answer, our ability to serve any type of administrative notice becomes very difficult. I'll touch a little bit on HUD home ownership, some considerations that need to be made that I've seen not be made in the past, and it causes problems for everybody. But when the home is paid off, you need to make sure that you know who owns the house and who owns title to the house. And oftentimes what happens when a HUD home is paid off, the housing authority will do like a mutual termination of the lease because, you know, HUD doesn't need to be in possession of the lease anymore. But then who has legal occupancy to the house? What should be done is an assignment of that lease from the housing authority to the homeowner. So just some things to keep in mind to keep others that have been in legal occupancy out of trouble in the future. If a lease is canceled, there's no legal occupancy of the land, and then after a homeowner passes, then who will own the home? And if that's not a provision that you put in your HUD lease or in your assignment on file, then that's always a matter of debate, a matter of argument. Y'all know how that happens when things go to probate. The administrative law judge is not going to determine who a homeowner is, not going to determine who owns the house. If somebody does execute a will, that kind of information should be put in the will just so that it's clear. But it's always a good idea to make sure that there's a beneficiary statement in a home site lease when a home site lease is present. Some of this, not really applicable, I think the leasing provisions, but this PowerPoint is in your packet on the thumb drive. So you have it for your future reference. But any landowner who's interested in selling should contact the agency with jurisdiction, and the agency can help you process through that, that land sale. A landowner can negotiate a sale of their interest to a co-owner, and that sale can be less than appraised fair market value if, in the opinion of the secretary, there's a special relationship or special circumstances which exist. The tribe will be given first right to purchase any interest in an advertised sale, and if that also goes with the fee patent, if somebody's applying for a fee patent, the tribe has the first right of purchase. Any sale or purchase must be approved by the Bureau. Without such approval, the sale is considered invalid. Through acquisition and disposal, a gift deed can be executed for co-owners to convey their interest to a co-owner without consent, and you'll see that the word entire is there. We have attempted policy, it's an unwritten policy, to try to eliminate further fractionation. We don't generally approve the splitting of any fractional interest. So if they want to convey their entire interest, we'll do that. Or if they want to have multiple grantees, we can do it as a joint tenancy with rights of survivorship. A landowner may make an exchange of their interest with another landowner in a different allotment, and that's something that we provide as a advice when, you know, sometimes individuals will end up with undivided interest on, you know, 5 or 6 different allotments, and you're not going to live on 5 or 6 different allotments if there's one that you're going to live on. And oftentimes the co-owners on all those allotments could be the same people. And when that happens, you could exchange those interests so that you're giving up interest in one allotment to increase your interest on the allotment that you want to live on. So we can do that as well. And it's our responsibility at the BIA to ensure that no coercion is taking place in a transaction, whether by gift or sale. For rights-of-way, we will end up at times with trespass through rights-of-way. As in any use of allotted land, a right-of-way must be consented to and approved. A right-of-way is an easement for a specific purpose, whether it be road, water, electricity, telephone, etc. And anyone who needs to cross property that they don't own or that they don't own other than a fractional interest must obtain a right-of-way for any access or utility purpose. What if someone doesn't have an approved right-of-way? That right-of-way is considered in trespass and can be ordered to be removed. We have that a lot, and I'm sure a lot of you in other states as well have that issue a lot where, you know, over the years, either a road was put in, whether it's a BIA road, a county road, a state road, or a tribal road, that was put in without a right-of-way, or even electric lines. We have electric lines that have been run that there was no right-of-way done. Those are considered trespass, and actually, I've not ever really had any real success in removing somebody from a property until I turned their electricity off because they didn't have an approved or recorded service line agreement or right-of-way for their electric service. That was the only thing that got them off the property. And there could be consideration for damages for an unapproved right-of-way or any other trespass. There could be damages that could be assessed through a appraisal that we would do. ABSO has done appraisals for us for trespass purposes before, and they've even gone so far as, I don't know if my appraiser's in the room, but they've even gone so far as to give us the calculations for what those damage charges would be, could be by fair market value. So those become essential in trying to figure out damages. I will say that some of the efforts that we make through the BIA, when we do get notice of trespass, we'll issue a cease and desist order or an order to vacate. Our procedure is completely administrative. We have an additional challenge in the state of California because we are a public law 280 state, and so BIA doesn't have any law enforcement in California, and we have a challenging relationship with law enforcement throughout the state. Sometimes we can get county sheriffs to come on and enforce one of our administrative remedies, but most times we cannot. If we do have some tribal police that have been, and I think Merri was going to speak to this, but we do have some tribal police that have been cross-deputized by the state, and they can issue those eviction orders. They can go and physically remove somebody from a property. They can do those kind of law enforcement actions. But those are some of the challenges that we have in the state of California because BIA doesn't have law enforcement. There are 5 states in the United States that are public law 280. And so those are some of the challenges that we face. We have tribes who've entered into MOUs and provide additional funding to county sheriff's offices in order to get some kind of cooperative agreement with them to exercise some law enforcement authority on the reservation. So it just kind of depends on the relationship that the tribe has, what agreements the tribe has or hasn't entered into with the county, and that kind of thing. So it varies. For us, we have 104 tribes in California, and our ability to cure trespass is hit and miss depending on those types of agreements that the tribes have or those types of services that the tribes offer through their cross-deputized law enforcement officers. So our process within the BIA is an administrative process. We issue those cease and desist orders or orders to vacate. We go through that process, and I believe some of what Rebecca is going to talk about is how and when a trespass, because in Public Law 280, there's a limited civil jurisdiction that the tribes retain, but criminal jurisdiction has been surrendered to the state. So that is our challenge in California. And so there is through that administrative process, there is a time when that civil trespass becomes criminal. And that's what we can help with, right? Oh, okay. So that's that. And I really apologize because while providing this information, I hope it helps somebody, but I don't have any solutions for trespass. I do have hope that there are some people within the department who are kind of taking the bull by the horns, so to speak, to bring people together to talk about this issue and how we can address it, what we can do to affect solving a trespass case. And I'm hopeful that in the future that's going to lead somewhere. But I've been in this line of work for 37 years. I started when I was 10 years old, but I've been doing this for 37 years, and I've not really seen a real solution affected for many trespasses, especially any that don't go into litigation. So for a simple residential trespass, for an illegal grow operation or anything like that, I've not seen any real solutions, or I don't have any real solutions for those scenarios. So if there are any questions for me, I'll take those questions now. And again, please make sure that you make your way to the microphone to pose your question.
Kelly George, I'm from the Umatilla tribe, and I have a question for you. We have a situation on our reservation where we have a non-Indian that bulldozed through 3 trust allotments, built on an allotment. This is going on 15 months. What's the time frame for the BIA to step up and issue the trespass order? What's the process for that?
So the unfortunate reality is we don't really even have regulations that address trespass and how we handle trespass other than grazing. And so it's an administrative process. Like I said, I'm here not representing BIA, only representing the Pacific region. So that time frame is dependent on your bureau office's staffing, workload, or ability to affect that type of transaction. We try in our region, we try to address those as quickly as we can because things happen very quickly. And so we try to address those quickly. But if you lean only on the regulations for grazing trespass, I believe it says that within 30 days, the Bureau is supposed to do their initial investigation.
But for building and trespass, you're not sure what that time frame is?
There aren't any regulations that give us a process for timeframes or anything like that. It really is dependent on the action your superintendent or your regional director is willing to take.
Okay.
Just to clarify what Kelly asked, does that mean BIA does not have that administrative process at all?
We don't have a regulatory trespass process other than for grazing.
Okay. I have a question on inherent right of way through the treaty. I've heard this stated by several different people that the tribe has an inherent right of way to go through any fee land that's within their reservation boundary. What do you know about that?
No.
I didn't think so.
I would lean to looking at the tribe's organizational documents. Again, you have treaty tribes that might have different authorities than non-treaty tribes. I've never heard of a tribe having that ability across fee lands, even within the reservation boundaries. They don't even, in my thought process of what I think I know, they don't have that right even across the allotments.
Exactly. And you would know that since you started at 10 years old. That's a lot of knowledge. You were born knowing. Can the BIA or the tribe through their 638 process lease out fee land within a range unit? So say there's fee land within an area, they don't fence it off, the fee land owner hasn't fenced it off, can they lease that out within their range unit?
No. They're not the landowner, right?
No,
No.
it's fee land, so,
No.
okay. So it would be, so that's a follow-up question would be, so the person leasing out the trust land allotments around it, they should be fencing that?
Either that or they should be contacting the fee owner to extend their lease onto the fee lands.
Okay, thank you.
You're welcome. All right, any other questions? Oh, man, I thought I was done.
Almost. So I have a question regarding the recording of the documents, right? So BIA does the TSRs when they're requested from the tribes. So for the recorded right-of-ways, is the BIA the one that maintains those documents?
Those are maintained in the TAM system, yeah.
So then if a request for a right-of-way that would have been requested or assumed to have been in place and it's not there, is it presumed then to not have existed?
There's potential cleanup that might have to happen. There's a record search that would have to happen. In our region, when TAMs deployed, we did a conversion. We didn't do clean data entry from start. So we have rights of way that got lost in the conversion, and we have to go back through microfiche and old records to verify whether there was any other rights of way on those tracts that exist. I'll also say that if you're dealing with a piece of property that was brought into trust through the 151 feet of trust process, those properties come into trust with exceptions to title attached to them, and those are not being recorded in TAMs as individual easements. That's something that in our region we're looking at, trying to figure out a way to perfect that so that when you do pull a TSR, any approved easements will show on your TSR as an encumbrance to title. But if they're not, for a fee-to trust transaction, if they're not recorded individually, then you would have to go to the Schedule B in the fee-to trust application to see which exceptions came into trust with that title.
So if you have an alleged trespass and you do your TSR search, nothing pops up, but yet you have the physical proof of, say, a transmission line coming through and there's no recorded deed, is there a statement or a document that could be gained from the BIA attesting to the fact that the BIA has no document showing that this right-of-way exists?
If that were to come to me in my office, again, I'm representing the Pacific region, not the Bureau of Indian Affairs as a whole, but if a request like that were to come to me by a tribe that there's an electric distribution line going across the reservation, they don't know of an easement that exists, we do the title search and we don't identify any existence of that, we would issue a letter to the tribe saying that a title search has been completed for that tract and there is not an easement on record for that transmission line, or whatever it might be.
And then drawing on your 30 years of experience, so you have the different regions, do they all have their own record depository?
No.
Is there a central one?
It's not a central one, but like for us in the Pacific region, we have our own LTRO. We also have 2 tribally contracted LTROs in our state. For example, Southwest region, if there's anybody here from Southwest region, you can help me out, but there's a LTRO at the Southwest region that I believe covers Southwest and Western region.
So then on behalf of all the tribes that are now staring at you intently, What is the mechanism that we can do to speed up the record request that we send to the BIA? So that's the end of your time, right?
No, I think Mary's logging in. Do you see that? So to answer that question, I'm going to get myself in trouble. There's always a chain of command, right? So if you go to your agency and you're not getting a response from your agency, you're not getting any action from your agency, you can always elevate that to your regional director. And then when you elevate to your regional director, if you're not getting any response from them, you can elevate it to central office. But you can also file an appeal under 25 CFR, I believe it's part 2, for inaction. And if you file an appeal under inaction, that's supposed to get you action. How effective is a Facebook appeal? Oh, we aren't authorized to use Facebook. So that would be my suggestion, is to elevate your request to the regional office. And if it's an LTRO thing, if the general public or tribes are not supposed to have a direct access to LTRO, that the agency or the regional office is supposed to be that line of communication. So I would just escalate it, and then if you're still not getting any attention, then file appeal under the part 2. I forget what it's called. Timely action or something like that. All right. Any more questions for me? Oh, man.
Good afternoon.
Good afternoon.
My name is Danny Gonzalez. I got 2 questions for you, if you don't mind. Once again, excuse I got allergies. Sorry.
I'm right there with you.
Okay. So, fixed structure, okay, on a property, single owner. Why is it that house doesn't become trust automatically?
Through statute, through APRA, I believe it was APRA, maybe it was something else, that in the past, before it was either the amendments to ILCA or APRA that defined houses as personal property. We all know anything in the real world, or maybe the real world's not the right word, but in the private sector, a house attached to the property becomes part of the real property, right? Well, one of those statutes, and I'm sorry, I don't remember which one it was, said that houses are personal property. And I believe that that was the out for the whole HUD home issue, because there were so many homes out there that once they were paid off, their leases were terminated, and then somebody, whoever the homeowner was, dies, goes through probate. The administrative law judge isn't going to determine who the owner of that house is, so it's almost an unknown as to who the owner of the house is. So for your own protection, if you're going to put a house on a piece of trust property, you should either in a will or somehow, if it's a provision in the residential lease or in a will, you should define who the beneficiary is to that house, that personal property, because technically even, and you'd probably have to take it to state court because our administrative law judges aren't going to address it, but if it were to go to court, well, it'd have to go to federal court, right? But if it were going to go to court, potentially the court could look at a will, because there's always a clause in the will that says all personal property goes to so-and-so. If we're defining a house as personal property, the court may, I'm not going to say they are, but they may even use that clause as that's who's going to be the owner of that house.
Okay, so if I have the house included in the lease, the initial lease, right, will that be enough to add it to the list of decedents, the inventory list?
Only if that lease has a beneficiary provision in it.
Okay. The next question is, if a person has a lease on property for grazing or home site, and the original owners are on that property, can that lessee file trespassing on them?
If they don't have a lease to,
No, they have a lease, but the original owners are on the property.
those original owners, if those original owners don't have a home site lease to be living on the property, they're in trespass, even if they're a landowner.
Okay,
If they have an undivided interest, let's say there's 3 of them, and they're living on the property, and they have an undivided interest, and either they or the other landowners by consent requirements have entered into a lease for somebody else, and those 3 owners don't have a lease for their occupancy, they're in trespass.
Okay, what it was a grazing lease where the person has a lease, good standing, and then other people were running their horses on there that were owners of the land. So the lessee has a lease with us, is in good standing, but they're not technically the owner, was my kind of my stale point.
Technically, when somebody has a lease, they're the legal occupant.
Okay, that's what I thought. Thank you. Have a good day.
Thank you. Oh, one more.
Just a quick follow-up question, Leanna from Paiute Shoshone Tribe, Northern Nevada. A follow-up on the home structures that are on an allotment land that is 100% owned by one person. They have a home, it's a HUD home. The lease is up. They got the home has been paid off years ago, but the lease by the tribal housing department gave them a 50-year lease. It's up in 2-3 years. Can that landowner ask them or require them to move their home off the land?
You started off by saying it was a 1/1. Right?
Yeah, one landowner that a family member was given the home lease.
So the home lease wasn't for the landowner?
No,
So if
the family member that was originally given that permission passed away, and his wife lives on there in the home.
as long as that house isn't covered by a lease, it's in trespass. Even if it had a previous lease, that's called a holdover. It's still a trespass, and they can negotiate for a new lease, but they'd have to negotiate for a new lease.
Got it, thank you.
You're welcome. Oh, 2 more people got up. Just kidding.
For an undivided interest parcel of land that has an owner in use authorization on it, and the same piece of land has a lifetime estate, when the person that had the lifetime estate passes, why would the Bureau of Indian Affairs terminate that owner in use lease when the actual owners had signed it?
If it wasn't, so the lease wasn't for the life estate tenant.
The owners of the land.
One of the other co-owners of the land has a bureau-approved lease.
No. The landowners that inherited the land did an owner in use lease so that the lifetime estate could utilize the property without interference from the Bureau of Indian Affairs. It was pasture land. So when that person died, the 5 owners still should have retained the owner in use lease, correct? Why would the Bureau of Indian Affairs terminate?
It depends on what the provisions and terms of the lease were. If the terms stated that it would terminate upon the death of the life estate tenant, then it would terminate. It just depends on what the provisions in the lease are.
Okay. All right, thank you.
You're welcome. One more?
Hi, thank you. But I'm from Alaska, and we have some really unique situations up there with our lands. And so in our villages, we have town site lots. You know, we don't have reservations, but we have town site lots where the BIA years ago helped facilitate through the town site lot acts and so forth. And then we have native allotments where if you prove use and occupancy of living on your land for 4 years consecutively, then you're given that 160 acres. But we have a big problem in the villages that have town site lots with the HUD leases. So if one owner, has a town site lot and then they go into default with the HUD lease, then HUD has attached another 25-year onto the 25-year initial lease, the first lease with the original landowner. They attach an additional 25-year lease in the event that they go default on their payments and so forth. So I have about 13 in several villages, homes that are released to a different family. The original family is, basically told to leave the house and so forth, but the land is still theirs, and HUD puts another family in, and it's just been a real pain because I'm trying to, close out some of the properties, the lots, and HUD's telling me that they don't have to give me the names of the new families that move into the houses on the other folks' land. I mean, it's just a real...
Some of those issues are those issues that we've taken up over the years with HUD about 15 years ago, and I think that's why the statute or the amendment to the statute that was made was because of the HUD issues. Because especially on allotments, it's a little bit different on tribal land, but especially on allotments, HUD will do that. When somebody goes into default, or if they're selling or manufacturing drugs, HUD has a rule that they can remove them from the home. So the original occupant is removed from the home, and HUD can place somebody else in there with an occupancy agreement. I've seen in the past where those occupancy agreements, somebody will take over a house, a HUD house, and it's only a couple of years old. Well, every HUD lease usually has a 50-year term attached to it, so that those people could live there for the additional 48 years in that they don't own an interest in the allotment, but they have the occupancy agreement with the housing authority to occupy that home for the term of the lease. But when the term of the lease is up, if they don't put another lease in place, if they don't get another approved lease in place, they have two options. They can leave, or they can move the house with them when they leave, but they have to leave because they don't have legal occupancy. And that is a continuing issue, and that is also, I believe, one of the reasons why homes were deemed as personal property.
Yeah.
So that the onus is on somebody other than the United States.
Yeah, well, this really, I think it's a real big problem, especially if a landowner is getting near their life, and then they have these heirs that they've, in a will, given their land to. Well, these heirs will never ever see their land because another family is living in the house, which has a different lease until it expires, and then they just sit there and no one does. I mean, I can't get anything from the housing authority to change it. And some of these leases were kind of made up when they were having all these issues with HUD at one time, so there's no signatures, and there's no approvals on them, and they were just thrown in the files to satisfy.
There's a potential to, I had a case, I hate these cases, but there was a HIP home that was built on an allotment, and the superintendent, through the HIP program, approved a residential lease for this woman who had lived in this house now for 38 years. She was an elder. I believe she was something like 89 years old. And that lease was approved without co-owner consents. So we had a co-owner who filed a petition to have that elder removed from the property, because that lease was approved inappropriately. It went all the way to IBIA, and IBIA affirmed that that lease was approved incorrectly. It was not a valid lease. It did not get the consents of the co-owners, so that elder had to leave her home.
Okay, thank you.
All right, no more questions for me? I'm gonna go ahead and turn it over, you're next, right, to Rebecca.
So my name is Rebecca Ross. It says in the materials that I work for the Department of the Interior, and that is where I started my legal career back in 2010. And so I started working in Washington, D.C. in headquarters, but I did a lot of work in the Pacific region, working with Kim and Regional Director Dutchke on fee to trust issues and litigation that came up around that. I did some reservation boundary work, other work all related to land. So a lot of my work centers on protecting lands and resources on lands. And so I wanted to share with you, the purpose of my presentation is to give you a sense of the process, both, it's a high-level overview really of some administrative remedies for trespass that are available through the Interior Department, but also if you want the United States Department of Justice to bring a lawsuit to address the trespass, I talk about that process as well, and also I'm going to talk about a few case examples. Before I get started, I just wanted to be more specific about where I work in the Department of Justice. I'm part of a division called the Environment and Natural Resources Division. We have 10 litigating sections in that division. One of them is called the Indian Resources section, so that's my specific office. And all of the cases we handle, we are trying to advance tribal interests through treaty rights litigation, lands-related litigation, defending agency decisions that are made for the benefit of tribes and individual Indians. And so there's 3 types of cases that we handle, and I've worked in all of those categories. Our trespass cases fall into the 3rd category, affirmative litigation, where we either join a tribe that's filed a lawsuit or we bring one ourselves, and we're acting, our client is the United States as trustee for tribes. So I'm sure everyone in this room already knows all of this information. There's, of course, 574 federally recognized tribes. The BIA and other federal agencies serve a population of approximately 1.9 million. And then in terms of BIA's scope of responsibility in terms of Indian lands, you have approximately 55 million surface acres across the United States and 57 million acres of subsurface mineral estates. This is a map I just wanted to include. It's from 2016, so it's out of date, certainly after the McGirt decision that we heard about over lunch. So, but I did think it was a good idea to include a map in here just to show the different regions and where Indian country, at least as of 2016, was falling across the United States. So as Kim mentioned, well, let me back up and say this. Trespass is a huge problem, I know, in California, but across the country. And in talking to, several people who work for tribes and deal with this issue frequently, tribes find ways to address this directly, oftentimes because they're frustrated by the length of time it takes for the United States government to get involved, which is a fair critique. And so I just want to say there's a lot of different solutions available here. I'm going to focus on the litigation side, but there's certainly a lot of solutions that don't have to turn into lengthy lawsuits. And sometimes the solutions can be faster and more effective and more amicable. But my world is litigation, so I'm going to focus on that. And I agree with Kim, if you're facing a trespass issue and you want BIA assistance, the best place to start is with your agency contact. And like she said, if you're not getting feedback, you can move up through the chain of command and go to the regional director's office, to headquarters. But that's really where it starts. And formally, what BIA likes to receive is a written request for assistance with a trespass issue from tribal leadership. And then that request is often submitted to attorneys in the solicitor's office at the Interior Department, which does both a review of the facts, especially if there's a need to get more factual information to fully understand the situation, but also review what is the legal authority for BIA to take any action. There's not a lot of authority for BIA to act, but there is some. If the tribe is requesting that the United States Department of Justice actually bring a lawsuit, you still start the same way. You start with BIA, that goes to the solicitor's office. The solicitor's office then does a review, and if they recommend litigation, they make a referral to the Department of Justice. And so for cases in our section, that referral would come from the solicitor himself or herself to the head of our division, and then it makes its way to our office, and our office conducts a factual and legal review, makes a recommendation, and then hopefully gets final approval from our Assistant Attorney General. I wanted to mention that in addition to our office handling trespass issues, I just wanted to point out that attorneys in your local U.S. attorney's offices around the country also have authority to bring trespass cases on Indian lands. So you don't have to go through a process that takes you to D.C., where my office is located. You can start in your own district, and that could be more effective for you. It all just depends on where you're located, if your tribe has a good relationship with that office. Even if you don't have a good relationship with that office, ask them, why aren't you bringing these cases? I don't, even though there's this procedure of approvals, nothing should stop you from reaching out to contacts that you have, either at the Department of Justice or at the Interior Department, to ask questions about what to do and what solutions might be available. I just wanted to highlight that tribes have brought their own trespass cases in federal court. The United States, if it involves trust land, technically the United States is trust title owner, and usually in cases involving trust title, the United States has to be part of the case. There is an exception when a tribe is bringing that case. It can proceed in the absence of the United States if needed. A tribe can ask the United States to intervene, but it's not, the case should be able to move forward without the United States. So the tribes don't necessarily have to wait for the United States to be involved. I did want to point out there's some exceptions to that. If the nature of the situation or the facts or the trespass involve an allegation by the tribe that the United States has some liability, then that could be a reason where a court could say you have to bring the United States into this suit. But if the tribe is saying this is our reservation, this is our Indian lands, this person's trespassing, we're trying to protect our lands from trespass, and that would be the same argument that the United States would make, the tribes can make it in the absence of the United States. And my last point here is that whether it's the United States attorney or our office, we always want to coordinate with the beneficial owners of the lands that we're talking about, whether it's the tribe or the allottees. Okay. This is just, I won't belabor this point. This is just more information about our authority to bring these cases. And then I just wanted a quick slide to just think about the different ways that trespass come up. We talked today about home site leases or people living on lands that don't have a proper lease, or maybe their lease expired. There's expired utility lines. You have examples of people coming in and removing property or destroying property. There's all different ways that trespass can come about. And kind of related to a point I was making before, there's so many different types of solutions. So, when I think about trespass cases, I think about what are the end goals that we're trying to achieve. It could be getting somebody off of the land, getting all of the property that they have on the property illegally, getting that off, remediating the land. If they've taken a valuable resource from the land and sold it and made money, recovering damages for that profit that they made. There's all different solutions that are available. So before I got into federal court litigation for trespass, I just wanted to highlight a few statutes that deal with, certain resources. You have, of course, agricultural lands. We talked about the grazing regulations that include regulations about trespass on agricultural lands. And then there's tribal timber resources. There's, provisions about protecting those resources from trespass. And of course, expired rights of way. We're seeing a lot of those examples happening. You could have an above ground or below ground utility line or pipeline, and for one reason or another, the right of way expires and it's not renewed, and there's litigation over getting that operator or trespasser to remove their line, or, depending on the circumstances, perhaps it's bringing that person into compliance. It just depends. And again, it's in consultation with the affected beneficial owner. And so just real quick, as Kim mentioned, if BIA gets to a point where it issues a notice of trespass, usually those do come from an agency superintendent, and those are subject to administrative appeals. That would go to the regional director and then ultimately to the Interior Board of Indian Appeals, which can take a very long time. I have a case that's cited here, Grenier, from North Dakota, where a person went on a property and started extracting a whole bunch of gravel with absolutely no permission, and it went through the administrative process. It's still pending. There's an extraordinary amount of damage to the property, and the remediation process has been delayed. And so there's things that BIA can do, but there's limits on what they can do and how quickly all of that can get done. And I feel like the Grenier case is an example of that. So, in terms of the Department of Justice bringing a lawsuit for trespass, our authority to do that stems from what's called federal common law. I don't want to bore you with a legal lesson, but they're just arise from court decisions over the years. And the different kinds of things that we can sue over are certainly the trespass. We can seek ejectment, so getting the offender off of the property, getting all their property off of there. Nuisance, if they're engaging in activity that's creating environmental or other harms. Conversion is just a term for if they've, like in my case, they've taken gravel and sold it and made a profit. Can we go after them, not only for the damage that they caused to the land and the fact that they didn't pay fair market value for a lease, but that they actually made a profit. So can we collect from them on that? These are just some cases that support our ability to go into court and ask for these damages. And then I just wanted to highlight a few case examples, some recent litigation that we worked on. This case is United States v. Thweet. This is Thweet. He operated a camping ground on the Colorado River Indian Tribes Reservation. Where that red dot is approximately where his campground was. It's a western boundary. The Colorado River forms part of the boundary of that reservation, and the lands where his campground were are part of the reservation. There was 20 years of actions by the tribe and BIA to, once he got a lease at one point, he was paying, and then all of a sudden he decided to stop paying. There were efforts for the tribe and also the BIA to get him to pay, to get him evicted. It was very difficult, so they came to the Department of Justice. We filed suit, and he left in the middle of the night. He just ran off, and then he never responded to our lawsuit. So we got a default judgment against him. We put forth our evidence of the damages that he had caused to the property, and the court approved that. And so the way that we're recovering it is we have, because the Department of Justice can work with different federal agencies, so we can work with the Social Security Administration, for example, and garnish benefits that he gets that way, or other federal benefits that he gets to make good on this judgment that has been enforced against him. This is an example from Washington State, United States versus Public Utility District 1 of Klickitat County, involving Yakima. And here, there was an expired utility line, expired right-of-way for utility line. There was a fire that broke out on the reservation. I think there's, dispute about the source of that. I think one party would say that it was at least in part, the negligence of the utility district in failing to manage those utility lines that caused at least some of the fire damage. And so BIA started an administrative enforcement process, and then on a parallel track, the United States filed an action under the timber statute that I mentioned earlier. The parties are in negotiations to try to settle this and resolve it. But I just wanted to highlight this because it's an example of not only the problem of an expired right-of-way, but the fact that it can lead to such extensive damage. And then, the recourse can be both administrative and also through federal court to try to fully address the issue. My last example is actually from Idaho. I put the wrong court name there. I put North Dakota was on my mind, so sorry about that. This is United States v. Howell. Leroy Howell and his wife operated a scrap yard adjacent to tribal trust land and a trust allotment involving the Nez Perce in Idaho. And they were also involved in gravel extraction, and they intruded on those trust lands. So the United States filed suit against them, and we claimed everything. We said, you're trespassing, you're a nuisance, you've taken gravel from the subsurface estate that's not as part of the trust resource and made a profit, so we're going to come after you for that profit. And then also, I think we sought damages for remediating the property and the damage that they had done. So a settlement was reached in coordination with Nez Perce and the beneficial owners of that allotment. So these are just a few examples, but I just wanted to give you a sense of the different kinds of things that can happen in trespass and the kind of outcomes that can come from litigation. So that's all I have to say. If there's any questions. I want to do Merri. That's fine with me. Can you hear us, Merri?
Oh, yeah. Can you hear me?
Yes.
Okay, cool. Sorry, I was just staring at all you guys and wishing I could zoom in. Hello, everybody. I apologize for having to Zoom with you today instead of being in person. Some things came up in Sacramento, and I needed to be in the office. First of all, I want to say thank you for inviting me to speak at the conference today, and much gratitude for Pechanga for hosting and inviting everyone in. They have a beautiful facility. And especially thank you to my co-presenters, Kim and Rebecca. You guys are amazing. So let me just introduce myself real quick, and then you can see a PowerPoint. Not have to see my mug on this Zoom, because I think your screen is really big, so I must be like huge. But okay, well, hopefully everything's okay as far as being on a huge screen. So my name is Merri Lopez-Keifer. I am the director of the Office of Native American Affairs at Attorney General Rob Bonta's office at the California Department of Justice. I serve as Attorney General Bonta's legal and policy advisor on tribal affairs. And one of the issues that has been raised is actually California trespass law as it applies to Indian country. And so I think we can go ahead and start with my slides. So little patience. I think it's screen 1. All right. So you should be seeing a big white screen that says California trespass law on Indian lands. Does everybody see that?
Yes.
Oh, thank goodness it's working so far. Okay. So that's our seals. So something that we discussed when we were planning this conference, when I was going to be in person, was to distinguish this presentation from Kim's and Rebecca's, because California is a Public Law 280 state. And so most of you in the room probably already know what Public Law 280 is. So that is the law that was enacted by Congress in 1953 and granted certain states criminal jurisdiction over Indian lands, and allowed civil litigation that had usually been done either in tribal or federal court jurisdiction to be handled by state courts. So very limited civil jurisdiction. The most important things to remember about PL 280 is that it didn't alter tribal law. However, it did make it so that the federal government's authority to prosecute under the Indian Country General Crimes Act and the Major Crimes Act was eliminated, and in its place, the 6 mandatory states, Alaska, California, Minnesota, Nebraska, Oregon, and Wisconsin, were allowed or authorized to prosecute under their criminal laws crimes that occurred in Indian country. And again, sometimes when I like to discuss Public Law 280, I like to remind people what it didn't do. It didn't reduce or expand tribal criminal jurisdiction. It did not abolish the tribal justice system. The mandatory states have concurrent jurisdiction for criminal law enforcement in Indian country. PL 280 also provided no financial support for this new authorization of criminal jurisdiction to the state law enforcement. And then, of course, court decisions have occurred when it comes down to the jurisdictional contours of Public Law 280, and this has actually generated a lot of litigation and law review articles, a lot of gray area, because it requires the analysis does the law, is it regulatory or is it prohibitory when you're looking at the state criminal law. So that was your fast and dirty Public Law 280 training. And the reason we felt it would be beneficial to start this discussion is because there was a lot of back and forth from our elected officials in California, the district attorneys and the sheriffs, and then also with the tribal leaders as to whether or not Penal Code section in California, Penal Code section 602 would apply. And that is our criminal code trespass, not a civil trespass. So the questions always came is, does section 602 of the Penal Code apply? And so there was a 1997 Attorney General opinion asking the question, and the Attorney General's office in 97 replied yes, but because of the way the question was presented, there was some confusion as to if it really does apply. So Attorney General Bonta did release guidance that said that criminal trespass is enforceable on Indian lands in California. And under that portion of the criminal trespass law, specifically Penal Code Section 602, Subdivision M. And just in case anybody has some extra time on your hands, take a look at California Penal Code Section 602. There are many different provisions in our trespass law. I believe it goes to Subdivision X. And then we also have multiple other code sections that deal with trespass. So we're really just looking specifically at 602 Subdivision M. And under that portion of the criminal trespass law, a violation occurs when a person willfully enters and occupies real property or structures of any kind without the consent of the owner, the owner's agent, or the person in lawful possession. So there is a specific intent crime. The Attorney General gave specific guidance to law enforcement saying what they could also use in order to satisfy the elements of the crime. And so that, what he did was he made sure that they understood that a tribal exclusion order that prohibits an individual from entering and occupying the relevant real property or structures could be used to satisfy an element of the crime for notice. So this is a breakdown of what the Attorney General's 1997 opinion provided. Again, this was regarding a very specific question presented to the Attorney General in 1997 about a tribe's exclusion order ordinance. It was attempting to mirror California's penal code for trespass. And in that opinion, it did say that in that situation, it did not meet the level of enforcement of our penal code section. However, it didn't foreclose the enforcement of 602, Subdivision M, which in 97, it was a different subdivision. So, last year, the Attorney General has several tools available to them when they are wanting to share legal opinion and guidance. So the first, obviously, is the Attorney General opinions, which are presented to the Attorney General by elected individuals or state representatives, like agency heads. Or the Attorney General can issue a legal alert, which would also provide legal guidance in a general application. And then there's the information bulletin. The information bulletins are housed under our Division of Law Enforcement at the Department of Justice. And this particular information bulletin was shared with all of our partners in justice throughout the state. So all of our sheriffs, municipal police departments, district attorneys' offices. And in particular, this bulletin was shared with the 34 counties in California that serve Indian country. We have 58 counties in California, and so we have 34 sheriffs and district attorneys that serve Indian country. This particular information bulletin can be found in 3 different places. First, our Judicial Council of California has a tribal court state court forum, and they have information specifically available to tribes and tribal courts. And so this information bulletin, I believe, is shared on their website. It may not be anymore, but the other 2 places are on the Department of Justice's website, and that's in our Division of Law Enforcement and at the Office of Native American Affairs, which I am the director of, under our tablet, our tab saying Understanding Public Law 280. The bulletin is 2022-DLE-04, and it is entitled Clarification Regarding Law Enforcement Response to Trespass on Indian Lands, and it was issued on March 28, 2022. And this bulletin goes into explaining the Attorney General opinion from 97, and then at the same time, making sure that it is clear to our law enforcement partners that California Penal Code Section 602, Subdivision M, does apply to Indian lands, so that there should no longer be any misunderstandings. This is my contact information. See, I'm super fast. And I guess that's why you keep me for last. But this is my contact information. If anybody would like me to send them a copy of the information bulletin, I'm happy to do so. My email address is on it as well. And then I think I can stop sharing my slides as soon as I figure out how to do that.
Can you hear?
Yeah.
Is Oregon one of the 5 states? And if so, is there a similar bulletin for Oregon that might be similar to the one that you've talked about for California?
So Oregon is one of the mandatory 6 states for Public Law 280. I do not know if they have issued a similar bulletin or opinion. I don't believe they have, but I can't say if they have yet.
I am with the Bureau, and I wanted to ask a couple of questions, maybe see if there's some solutions. Does Department of Justice have a dollar limit on when they'll take a trespass case?
You mean in terms of damages?
Yes.
In order to get into court? I'd have to, I don't think no, I would say no, because there's no threshold. I'm not aware of any sort of threshold. I think if what we usually encounter by the time issues come to us at Department of Justice, it's been an issue for a long time. And what we can do is recover damages going back 6 years plus 90 days, I think. And a lot of times the issues we're dealing with, the problems go way back beyond that. So I don't know of any threshold requirement in terms of damages.
Okay. Do you think the issues here are what law applies, which court you have to get an order from, and who will enforce, right? Do you think an MOU with Justice, Solicitor, Bureau, and law enforcement would help? That's because there's no answers to any of those questions that we can rely on. So, I mean, I'm in the Bureau, we've had the same problem. Kim alluded to some of it, but to me, an agreement on that would go a long way towards solving the problems and streamline the litigation report by everybody would agree, and then we wouldn't have to wait for a litigation report in order to get it to justice. And something where justice would agree, under these circumstances, we will take the case. So anyway, I'd like for you to take that back, that we all sit down and try to get an MOU together.
I mean, I think that's a great idea. I want to talk to Kim more about, the work that Interior is doing to look at this issue nationwide and think about solutions. If there's a role for Department of Justice to be in those conversations. I mean, I know myself, I'm a line attorney there, but every time I come to a conference and talk about trespass, I just hear about more and more instances of it, and so I think all good ideas are welcome, it sounds like.
And just one last thing, the scope of the problem is bigger than you realize, because back in 1980, they had a law that said publish every trespass you can find, and the Bureau published 35,000 potential claims for damages. A lot of those are still outstanding with no statute of limitations whatsoever. I've always thought the Bureau needs to finish the job, basically, see which ones are truly in trespass, and then again have some MOU that when we're going to take those cases, because those are unlimited in damages. We're not going to usually get damage. Let's face it, if the tribe wants the road, they're going to waive damages. If the tribe doesn't want the road, somebody's going to have to go in there and enforce. And I've been frustrated for 35 years trying to deal with this issue. So I just wanted to bring those things up for the rest of the audience. Thanks.
Yeah, thank you.
Looks like there's no more questions. Thank you very much. Thank you for all of our 3 great speakers. They were fantastic. Oh, sorry, one more. Sorry. Okay. And then, as a reminder, turn in your evaluations. They're always helpful for
I
us.
just have one quick question. So I have an electrical company that's in Trespass, and this Trespass was noted when the BLM was doing a field exam on this native allotment. Well, it passed and the native allotment was certified to the owner. But the problem is, you know, our forester went out to the native allotment, and they saw that the electrical wire is, you know, intertwined in the trees. So this could cause a real potential burn in the area if something were to happen. It's not properly put up on poles. It's hung from tree to tree. And that's a big trespass that never was dealt with back when this native allotment was certified. What can we do about this? Because TAMS won't close it because of all these issues on the native allotment. So we can't even get certified TSRs.
I'm totally intimidated now. I didn't know Stan Webb was in the audience, so man, now I really got to watch my P's and Q's. But it's the same thing. It's a trespass, and you would need to start at your agency, local agency, to file a complaint of trespass and go through the process. And yeah, it sounds very dangerous and, you know, a potential hazard, but that you would need to start at your agency.
The interesting part too is, so what happened, I was reading through the old files and through BLM's notes and so forth, but the interesting part of it was initially going to be a trespass, and then the realty specialist that was at the BIA back in the 80s pulled it back and said, well, I have no evidence here that there was a trespass. So then they started doing revocable use permits with them to go and, you know, do the tree limbing and so forth from that point on. And then now it's just grown so thick that no one's doing that, and it's just a big mess.
Yeah. Sorry, I don't have a real good answer for you, but now that I know Stan's in the room, I can't say anything. No, I'm just kidding. Yeah, I would just start with trying to work with your local agency, and if you're not getting any satisfaction there, escalate to your regional office. Okay? All right, we're done. Good job, Merri.